So Matt,
Oh, Matt. Thank you. I'm the same, you know. So you want me back there for a headshot?
I just have a special chair
Oh, okay.
where the cameras.
So good.
Yeah, it's just taking image.
Ouch.
Hey, I bought that. I bought two here. Fresh. I have it. It's not in my shirt. Just have you seen your nieces? No, it's not.
What's that, Jim? Got all kinds of it. Was this better? I dropped it down even further. How's it? Yeah, better. She was referring to me. You're chasing your tail.
They're just trying to be able to walk through.
Someone's quiet, but what is the bonus?
That's what I feel like. Walking in circles.
So today, all you got two houses in the building. And I just run from house to house. Putting out fires and taking kids out.
Yeah, well, that's a good thing. I mean, when it's outside, it's horrible. It's kind of weather.
How for
I haven't.
Get to St. George.
Yeah, about 8 o'clock last night. After they finally said, just go into the urgent care. They've got all your stuff there. Go to the luggage, time level, or
We're all past that. Okay, let's go ahead and get started. Honorable Garrett Smith has this first portion of our meeting, and he's going to, let's just turn the time over to him. We'll
All right,
probably, not probably, we'll be going into a short closed session too, as soon as Garrett's done, before we start our meeting, just so everyone's aware of that.
All right. I don't know who's in control of the screen that's presenting. Brandon, could you just go to the right screen that's showing the Open Meetings Act? Okay. Kind of made it bigger, so I'll just go in. But Brandon, if you hear me, just click on the screen on the right that says Chapter 4 Open and Public Meetings Act, just for the one that's going out to the broadcast. Okay, so as we get started, I'm going to come down to page 3 under training. So this is 52-4-104, and I will email you a copy of this. Sometimes it's just nice to have. I highlighted the ones that I thought were most relevant. But it talks about how the presiding officer or the chair of the commission ensures that members of the public body are provided with annual training on requirements of this chapter. So that's what we're doing now. Typically, mid-year, after the legislative session is over, I'll come back and talk about any specific changes that have been made. But that's, this is under the direction of Chair Wilson now, and we typically do it just at the first or second meeting of the year. And it's required for our audit. I think one year it wasn't in the minutes, and so we had to go back and figure out when we did it. But it's a good part. It's a good thing to, it's a good reminder to have.
So Garrett,
Yes.
I've done this training before, but do we need to go online and do it and get the certificate?
No, this will count
This
for
counts as
it.
it?
Yep. So it does reference another portion of the code under 63G, which is a lot of the government operations. As I was reviewing it again today and just marking out the specific provisions I wanted to go to, I thought, well, let me just make sure on that cross-reference. And it is just talking about when we do this training, you either have to be in person, or if you do a training online, you have to get the certificate, but this will qualify for it. It doesn't hurt, though, to do the online training, too, because they may bring up other things. I've tried to focus this more to this body and the things that we typically have come up and deal with. And as we go through, ask your questions. I think that's great, because then we'll just address it as we go rather than, writing something down, saving it for the end. I think the overarching intent is captured really well in section 102. Just that as a legislative body here, this really is the closest legislative body to the people. And some people can call their state representatives, they can call their, federal representatives as well. But as far as having access and having interactions with the people who elect you, I think it's really cool as county officials that we are very connected and close to the people that we represent. So that being said, the intent, if you see under subsection 2, it says it's the intent that as a commission, we take our actions openly, or you take your actions openly and conduct your deliberations openly. And as we go through, and it's talking about a quorum, and it's talking about not discussing as a quorum, there's a little bit more gray area in a 5-member commission than a 3-member commission, because in a 3-member commission, if 2 of you are talking, then that's a quorum. So technically, there's a little more gray area for 5-member commissions, but as a general rule, you don't want to be having all of your deliberations off record, because under the GRAMA statute, which is Government Records and Management Act, the public, they have a right to transparency, and the state legislature really is encouraging and promoting that. So once again, of course, any actions we take as far as votes and things like that, that shouldn't happen outside of the meeting. But even your deliberations, when possible, you want to have in the meeting. There are some exceptions for operations, which I'll get to that in the definition, because you have both legislative and executive function. So you're the legislative body, but you're also over the implementation for the county. So there is some overlap there. But as a general rule, or if you're concerned about, should I be deliberating this, I would err on the side of waiting to deliberate in the meeting, just so there's that transparency. And if you have questions, I think you can ask me.
I don't want you to take a ton of time on this, but I'm just interested to know, like in the federal government, you hear all the time that the Senate leader will say, I know we have the votes to pass this. So obviously they're deliberating in other areas than they're supposed to be, correct? Is that right?
That's correct. In fact, I'll probably jump to that. Let me just find.
Because what applies to us doesn't apply to them, unfortunately.
No, so
Their own rules.
yeah. So locally, we're more transparent than the federal government, which I think is not a bad thing. So let me jump to page 15. So here in section 208, it says individuals constituting a quorum of a public body may not act together outside a meeting in a concerted and deliberate way to predetermine an action to be taken by the public body at a meeting on a relevant matter. And so what it's saying there is you're not supposed to go and count your votes. There's going to be things that come within the meeting that may change your mind. We can only make decisions. I always say my outputs depend on my inputs. And if I make an output and someone starts giving me inputs that make me realize, you know what, I probably was too hasty in my position on that, or, perhaps I need to rethink that decision based on the new information. And so I think it could also cause some friction if you thought you had the votes and then it didn't pass. And, I don't know why. I don't think I guess I'm just thinking that as more of a function of government, that I think we all work better together when we're getting along and understanding each other and things like that. But as far as being transparent to the people, we don't want to have all of the meaty discussions not like outside of the public view, because then the public is taken out of it, and the representation form of government is really there to help people want to be more involved and be aware of what's going on. So
So may I ask a question?
yes.
So within that, when we are discussing, I mean, everything that we're discussing, such as in emails and stuff, those are all grandma requestable.
Correct.
So, what is wrong with us discussing those items through emails, and so that way we can get a better understanding of what somebody might have been thinking about certain areas? What's wrong with that?
So, I guess what's wrong with
Making a
it
decision,
is
we're
that
just
you're
discussing.
you're deliberating outside the meeting, right? Like you want that deliberation to be in the public.
Okay, and so then, what is the difference then between doing that and bringing up sore subjects inside a public meeting that we don't want to bring up? How are we going to do that?
So,
You talking about things that would offend others, or?
Yeah, possibly, it might offend others. It might
Yeah,
offend
and-
others.
and
And see,
I-
and that's the problem that I can see as, and it occurred with me, of course, and I don't want to see us, because I was told that we had to do it in public discussion. And if we're not doing it in public discussion, then where else are we going to do that discussion? And I don't want to pinpoint to certain people or anything like that, but that we've got to have that discussion, either whether it's in public or in an email, that we can go and discuss it without offending anybody, hopefully, or getting in a hard, heated discussion. And I don't want to see us do that. I don't want us to be in that position again that I was in last year, in July, and August. And I think we need to be able to discuss those items openly and freely. And how are we going to do it if we don't have some prior ability to do it through maybe a discussion through email? So that way it does not become heated.
yeah, I think those are great questions, and I'm just going to present on what the law is, and maybe the law needs to be changed, right, to address some of those things you brought up. Meetings can be closed for certain things that we'll get to as well, and that may be an appropriate way to talk about some of the sore issues if it qualifies to be talked about there. I think additionally, sharing information is not a deliberation, right? And so if you are sending out some information, but you're not discussing that information, you're just saying, hey, I saw this is on the agenda. Here's some conversations I've had. Boom. That you're not deliberating at that point, right? You're not counting your votes. You're not getting feedback necessarily. You're just giving more inputs so that when you come together for the output, everyone's more fully informed. So let me hit on a couple of these, and then let's come back to it and see if maybe it can provide a little more direction. If I'm being honest, I think sometimes when the legislature tries to make this more clear, it gets harder for me to interpret as well. So we'll go through. I know that they changed a lot of this last year, where they used to have a definition for what is not a meeting, and they took that out. But then they changed the definition of relevant matter. And so I think that's where we could say, okay, maybe this is where we'd say it's not a meeting, okay? So a meeting means a gathering of a public body or specified body with a quorum present, and that is convened by an individual with authority to convene the public body or specified body, and following the process provided by law for convening the public body or specified body, and for the express purpose of acting as a public body or specified body to receive public comment about a relevant matter, deliberate about a relevant matter, or take action upon a relevant matter. And so when we're looking at a list of things and it has the or, you only need one of them. If it has the and, you need all of them. So here, where it's talking about the express purpose of acting as a public body, deliberate about a relevant matter, it's in the disjunctive, and so even deliberating, you're having this meeting, which is the gathering of a public body. So once again, I'm going to come back to your question, Commissioner Fackrell, but let's just come down to public body. This commission qualifies as a public body because you have executive and legislative authority. and it is created by the Utah Constitution, statute, rule, ordinance, or resolution, consists of two or more individuals, expends, disperses, or is supported in whole or in part by tax revenue, and is vested with the authority to make decisions regarding the public's business. There's quite a few public bodies within the county as well. I think in the past, there's been times where there haven't been notices of all the public meetings of all the public bodies, but I think that we're doing much better on that and making those recordings so that everything can be done transparently. Expends, disperses, or is supported. Sometimes there's a question of whether a volunteer body qualifies under that, but to a degree it is supported, especially when a commission member is on that committee or board with other volunteers. So just kind of keep that in mind. All right, so here's where we kind of get to what used to be considered not a public meeting or not a meeting. So under subsection 11, it says relevant matter means a matter that is within the scope of the authority of a public body or specified body. Generally, everything that we discuss here is within your scope. And so most everything that would be on the agenda would be considered that relevant matter. However, it does say relevant matter does not include for a public body with both executive and legislative responsibilities a managerial or operational matter. So for example, when we have our management meetings and we're meeting to discuss how to implement something that's been passed in a public meeting, and if 3 or more of you came to those management meetings, that wouldn't be considered a public meeting that we'd have to notice to the same degree, because it's about coming together for that managerial purpose. So getting back to, I guess, Commissioner Fackrell's question about the emails, I think the one that we jumped to ahead with Chair Wilson's question about predetermining something, if you're not convening, right, if we go back to public meeting, if it's not convened by the chair or at the chair's direction, then you're not necessarily having a meeting. I mean, it's still grammable, and maybe that was your question, and maybe I'm understanding it a little bit better now. It's still grammable, but you're not convening. You may be deliberating about a relevant matter, but you do not want to predetermine your votes. So maybe that provides a little bit better clarification, is as long as you're not convening, there is a section that talks specifically about electronic communication. And if I can find it quickly, I'll go to it. If not, I'll just hit it. Okay. So page 17. It says nothing in this chapter may be construed to restrict a member of a public body from transmitting an electronic message to other members of the public body at a time when the public body is not convened in a meeting. So maybe that's more on point with your earlier question, is as long as you're not predetermining the outcome of a vote or saying, hey, this is how I'm going to vote, or this is how you should vote, or something like that, as long as you're not convened in a meeting, you can send those emails. Does that give a little further clarification? But I think, you know, at the end of the day, oh, go ahead.
I think I understand it, but I was, after that meeting we had last year in 2024, legislative meeting, it was discussed that we cannot go on, we can no longer do emails and vote like we had in the past. I understand that, but then they said we need to have all meetings when you're discussing even administrative items, executive, legislative, whichever one it is, we need to be discussing them in the public. So if there's a problem, then that means we should be discussing them as a group in here, in a public meeting with people watching us, as we discuss these administrative things. And so that is
Okay.
why those things occurred last year for me, and where I figured I can't go into a closed session on those things because they did not meet the items of that closed
A
session.
reason to close the session.
That's right. And so they had to be discussed in open, and anyway, history is history.
Okay.
Okay.
Well, maybe we can talk offline specifically about that, so I can, because I'm
I just
trying
want
to.
us to be clear as to what we're doing
Right.
in these meetings, because we need to be aware of everything that everybody else is doing. And if it involves all of us, we need to make sure that every one of us discuss those items, whether it be with the public here or wherever it's at. We've got to have it recorded if we're going to discuss these things openly with more than two at a time. So, like the emails I send and Raylene, we've sent back to the commission, and then we're told we can't talk about those things except in an open meeting. Well, those emails are actually grammable. They can go back and they can look at those. We're not speaking as a group, but we're relaying our information to everybody here, and we don't need to have the discussion go back and forth. But now tonight we're going to be discussing those items here tonight, and I hope it doesn't offend anybody.
Well, I think we can discuss concerns. I think what happens is sometimes we say something disparaging or that may not be truthful to everyone, you know, and so when we start making accusations or be disparaging or things like that, putting people down in front of the public, then I think we've crossed the line. But you should be able to bring up a concern. I'm concerned about this because of this, and be fine.
As long as we can do that.
I think as long as it doesn't go towards the predetermination,
Right.
If you're predetermining what you're going to do, then that's not allowed.
Right.
But like we were looking at on the screen here, it's not restricting a member of a public body, so it wouldn't restrict Commissioner Fackrell or any member of the commission from transmitting an electronic message to other members at a time when the public body is not convened in a meeting. So if we're not convened, we're not at a meeting that's been noticed and gone through all the process, and you send an email, that's fine, except as prohibited by the Open Meetings Act, which would be predetermining something, taking a vote on something, right? So I know,
We stopped that last year.
yeah, I know that I haven't been good at following that in the past, and maybe it was just my understanding. Sometimes we would, kind of get everyone on board and then ratify it at the next meeting. It's like, okay, but now there was really no public opportunity for public comment. We've already made the decision. Is that really transparent? And so I think it would be fair to say that I haven't always enforced this correctly, and hopefully the more I read it, the more I participate in these legislative meetings to understand the intent, the better recommendation and training I can give.
Okay, because tonight we have some items that are on the consent agenda that I'm wondering if they should be actually in open discussion, whether or not they're just a quick approval or not. Some of them I'm wondering if the public ought to know them without having to go to the packet to figure out what they are, instead of us just, and that's what I'm noticing is we're getting a bigger and bigger a consent agenda, and by having a bigger and bigger consent agenda, we're basically in that consent agenda passing a resolution that the public ought to hear about. They ought to see some of those different things that we are actually consenting to other than just on this sheet here. Or if they go back and do their research later, if they want to know what we actually did, I think we ought to, whether or not it's just for a minute's time that it takes up outside of consent agenda and in actionable items. And that's just a concern that I've seen, and I think we need to really look at that, whether or not we're continue this practice or we continue it according to these Public Open Meetings Act. So just to let the public know, and that's all.
Yeah, and I think if there's any that you have a concern about, you can always withdraw it under our policies and procedures. You can pull it from the consent, so that it does become more the action item. But I think maybe what you're going to is the next, well, maybe not the very next section, but I think it's 2 sections from now, where it talks about having enough specificity in how it's posted to give the public notice of what's going to be discussed. Is that more what you're getting to?
Well, I'm just saying that I think if we're gonna have things open to the public, they ought to be open to the public, and not for them to have to go and necessarily go back and do all the research that we've done to discuss those items openly here or wherever we're doing. We ought to be discussing them here. And I mean, it may be fine with everybody else, but everything I've read in the Open Meetings Act, we need to make sure that we're declaring those things or letting people know of what it is that we're intending to pass, because this is a passing of an item. And yes, we have read the information. Maybe they didn't read the information, and maybe they need to know the information. And that's my only.
So like on our consent agendas, give me your,
My things is like, I mean, and I'm okay with them all. I could pass them all in
no,
consent agenda,
I understand that.
but
I'm just saying, which one do you think should be brought before
like,
the public?
for instance, the library or the Historical Society Board of Trustees. Should that be brought up for a discussion, or do we just accept?
The resignation,
Well, no, we can accept resignations, but I'm talking about the appointment.
the appointment, wasn't,
Because it doesn't even have it here as to who it is we're appointing. It's just got a consent agenda here, says approval of resolution CR 2505, resignation and appointment to the Morgan Historical Society of Trustees, Board of Trustees. And there's no names in there, so how is that letting, or is that open to the public? They should be able to know who's on that board, and it goes through in our packet, and it discusses it as to what's there. But those items ought to, in my opinion, from what I've read in this legislation, is we should have that open to everybody, not just to look it up and see it in the packet, but to be able to hear, okay, this is who we're appointing for this position, or whatever other item it might be. So,
Well, I mean, it is open to the public because the packet is also posted just like the agenda. I think what you're suggesting is maybe there's, and maybe I can start going through because it might answer some of the questions, and there's things that the commission may do to give more transparency, right? This is just the bare minimum. And so something like that, I don't see that as,
Okay,
it's not
so-
complying with the open meetings, it's just maybe not giving the specificity that you prefer.
well, what I'm
Mr.
saying.
Chair, can I make
like,
2 suggestions
Yeah,
on this?
go ahead. And
I
then I'll-
think maybe to deal with that, if it's a resolution, perhaps we don't put it in the consent items, period. All resolutions go in action items. And then maybe we just read through the consent items. Just verbally read through it in the meeting and then vote on it. We don't have to go into detail on every item, but we could at least read the agenda and say these are the 10 items or whatever we're voting on in the consent agenda. Would that
Well, that would work. I'm just
Would
saying.
that appease your concern?
Well, that part would, but what I'm also looking at, approval of a letter to support Mountain Green Fire District. Hey, I'm all in favor of that. But the public doesn't see what that is. We haven't discussed it. Or the Liberty Broadband thing. Yeah, I'm in favor of it. But what I'm saying is the public has no clue what it is we're talking about unless they delve into more detail and go into and ask for a grammar request to find out what it was we were talking about. For instance, the
They
Liberty
shouldn't have to do a
Broadband.
grammar request because they can get the packet and
The
it's in the
packet.
packet.
Right, it's in the packet, but I'm just saying, they're gonna have to go to more detail. All I'm saying is if we've got to have things more open to the public as to what we discuss, unless we go into a closed session. That's all I'm requesting.
Okay.
So, I mean, if I was a public sitting out there and I did not read the packet and I'm coming here to listen to different things on the agenda, I'd like to know what's on it before I just stop in the meeting. Well, I don't have my computer with me, I can't look it up. I'm never gonna see that. But as a public member, I would like them to be able to see that information as we go through it. It can be a quick 30-second passing. But we've got to let the public know what we are actually discussing. I mean, a $17,000 grant is great. I think it's great. Hopefully we can get one up here too, or or maybe us partnering with the Liberty Broadband, that we will help them in whatever way we can, or whatever one. We're going to give our support to whichever one wants to come into our county and do some improvements on technology. Those kinds
Do
of
any of
things.
the other boards you sit on ever do that, Blaine? Because all the ones I sit on, they just have a consent agenda, and they expect us to do our due diligently before it's
Well, it
it's
depends on
done.
how many items are on there. Most of the time, you'll see 2 or 3 or 4 items on the consent agenda, which is only really tiny, small.
Well, Weber Morgan Human Services has more than we do, but
Oh, do they really?
absolutely, yeah.
And maybe
so,
they need to be taught this same stuff.
well, I don't know. I don't know what it
That's
fits
what I
in.
don't know.
I mean, that's the point I was making, though, is
I
that
would like a
it complies
clarification.
with the act if there's things that, as a body, you want to do to go above and beyond. But we're just talking about the bare minimum now.
Right.
And I think for time's sake, I'll probably just hit some highlights and then maybe
I'll
come
stop
back.
asking. Yeah, we
and
can.
and we can still come back to some questions.
That's fine.
But maybe there's a follow-up that we can have too, and then maybe come back for another discussion on the act.
That's fine.
throughout the
That's
year.
fine. I'm
Okay.
okay with that.
But I think just to hit the highlights, especially for our new members who, I don't know if you've read through this before. I know you've watched quite a few meetings, so you've seen how we do this. But when we convene and it qualifies under that definition of open meeting, then it will be open unless there's something in this code that allows you to close it. So everything is going to be transparent. There's certain items for discussion that are more, I guess, protected information involved, and so you can close the meeting for that. Under here, it talks about that it's open, like including workshops, executive session, where the quorum is present, except when closed. I don't know that we've really done many site visits, but typically any workshop, work session is going to be right here at the anchor location. It's going to be on the same day. If you do a site visit, then there's some other things that you have to make note of. If you're making a vote, for example, you've got to have minutes and things of that nature. But once again, it's to give the public an opportunity to be aware of what's going on and to be involved if they choose to. So there's always that 24-hour public notice, and so every once in a while on a Monday we'll have to switch something or add something or take it away, but typically Kate will try to get it out the week before on the Thursday or something so that the public has enough time to look at the packet, but all that's required is the 24 hours notice. So I think that goes to Commissioner Fackrell's point, is we try to get it out on Thursday so that there's the weekend, there's more time, but the bare minimum is 24 hours. And then, of course, we've got the agenda, time, place. Under subsection 2, this is why we always approve the meeting schedule for the year. It's required by law, but it's also good for us to be aware of when we meet and any changes to that. It talks about publishing as a Class A notice. That's referring to the Utah Public Notice website. It used to say that we had to put it in a newspaper of general circulation and things like that, but as times change and more things going online, that's been the direction where now, as long as it goes on that public notice website and then they post it somewhere in the building, like at the anchor location, then that's sufficient. All right. Sometimes you don't have to give that 24-hour notice. We may have talked about this at the last meeting. It's kind of ringing a bell that we had a COVID meeting once, and I don't know if we had 24-hour notice or not, but it wasn't a regularly scheduled meeting. But even in those instances, you're trying to give as much notice and transparency as possible, and it does require that a majority of the members of the public body approve the meeting before you have that. And so, once again, it's as much notice as you can bring. I think that this one comes up occasionally under 6B. It says, subject to the following section, at the discretion of the presiding member of the public body, a topic raised by the public may be discussed during an open meeting, even if the topic raised by the public was not included in the agenda or advance public notice for the meeting. So someone, Deep Creek was on the agenda, but let's say that someone in public comment was talking about Deep Creek, and the body, under the direction of the chair, says, well, let's talk about that a little bit. You can do that. So that's up to the commission chair. However, if you look at C, it says you can't take a final action on a topic. So you can vote on an action item unless it's properly noticed, unless there's some sort of emergency. And that's what it says, except as provided 5 relating to emergency meetings, you can't take final action. All right, written minutes. I guess the only point I'd bring up here, you're not really having to manage that as much, which is good, but you do want to review the minutes to make sure that it's accurate to your memory, because whatever goes into the minutes is the official record of the meeting. You may remember that we used to say this person made the motion, this person seconded, and it was unanimous. This does require that for an elected body like you are, so Katie will have to record in list format each person's name and how they voted. And so if you remember, that was a change from what it used to be, where we just said unanimous or this person voted opposed. Okay, this one, for specifically Chair Wilson, if someone comes to an open meeting and they're presenting something in an electronic format, they need to, or a hard copy, they've got to provide that for inclusion in the public record. So for example, I don't know that I've done this before, but I'm going to email out this highlighted section so that it can be included in what I presented, because on the agenda we just had the link to the code itself. But since these ones are highlighted and I'm presenting on it, I should give you a copy so that it can be included in the public record. But sometimes people will come and they'll have handouts. If they provide that handout, it should be included in the record as well. All right.
Have we made it clear to the public yet, since that bill passed last year, that states that a public member can ask to talk during public comment section time electronically if they so desire? Have we made that available yet?
Yes, it's on the bottom of the notice.
Okay. I just want to make sure.
Yeah. Yep. All right, so this is just talking about the minutes. I don't think that's too important. Okay, so here, I know there's been some confusion because under A, it says 2/3 of the members of a public body present at an open meeting vote to approve closing the meeting. But then B says for a meeting that is required to be closed if a majority of the members. And so the difference is, and then an ordinance, resolution, rule, regulation, contract, or appointment may not be approved at a closed meeting. You can discuss it, you can't approve it. But then here, it says may only be held for, and then it goes through, the typical ones that if we close a meeting, these are the ones that we close it for. Then under subsection 2, this is where it says shall be closed. So if you're going to a shall be closed, you only need a majority. If you're going to a may be closed, you need 2/3. So for this body, we need at least 4 out of 5. If it shall be closed, then you need only 3 out of 5, and that's the distinction. Some of the typical ones for closing a meeting for this body are, A through G. So discussion of the character, professional competence, or physical or mental health of an individual. collective bargaining, pending or reasonably imminent litigation. You've got purchase or sale of property, and then deployment of security personnel, devices, or systems. Once again, if that's for the building, we don't want that to be public record of how we're going about that. Investigative proceedings regarding allegations of criminal misconduct. I highlighted that one because it could come up, but it hasn't been a reason that we've closed this meeting before in the last 3.5 years. Any questions on that? All right, we've just got a few more minutes here. So here are some restrictions on what may not occur in a closed meeting. No interviews for a person applying to fill an elected position, midterm vacancies, which this commission doesn't fill anymore out of since the change in government, but even discussion of that is not allowed. And then you can't discuss character, professional competence, or physical and mental health of a person of a name submitted to fill that midterm vacancy. So, got that there. Recording closed meetings. We've got that handled, so that's not something that you really need to worry about, but it is recorded. And so we shall keep a recording. We may keep detailed written minutes, but it's not required. And then there is an exception that if it's closed for something specifically that's allowed, like the character competence or the security personnel, those types of things, then you don't have to record, but the chair would have to say this is the only thing that we discussed. Now, if we go beyond the scope, and you'll see this, sometimes it happens, and I'm tasked with keeping us on topic, and that's, I don't always do that, but I'll try to say, okay, that's going beyond the scope of the closed session, let's bring it back to this, or let's talk about that when we reopen the meeting. The reason I'm doing that is if there's a challenge and things that were talked about that maybe in your mind you're thinking, well, that's a closed session, it's protected information. If a judge were to find that it wasn't a valid reason to close it, then those portions of the closed session could be given transparency, because once again, it didn't qualify for being closed all in the beginning. All right. I know we're going to have a brief closed session. I think other than that, those were really the highlights. We have created rules and regulations for people joining remotely, so that is allowed. We do have this here. There's a question about voting by proxy, but there has to be a rule regarding voting by proxy. And at the last discussion when we were talking about it, we said, well, what if information is presented and now you've got this proxy vote that is not fully informed? So once again, that's something that you could discuss, but it's not essential to our current rules and regulations. I've already talked about that. So the reason that these are really important is, let's say that you make a final decision, but that becomes voidable by a court because we didn't comply with a technicality of the Open Meetings Act. So this is, once again, the bare minimum. We want to at least comply with that. If we fail to comply with that, then someone could sue to enforce that. And if they do, then that could be voidable, and the court may award a prevailing plaintiff a reasonable attorney fee and costs. And so there is some financial liability. So that's why we sometimes, if something is wrong with the notice, we err on the side of caution of re-noticing it rather than moving forward because of the potential voidability of those decisions. Here, so the Attorney General and county attorneys enforce the chapter. And once again, the court, like if someone sues to enforce it, then the court can award reasonable attorney's fees for that. Kind of talked about that already. Class B misdemeanor for violating, and so especially a closed session, when that happens, you'll want to keep all of that in the closed session. If there's an action item and there's something, well, action, not necessarily a vote, because we can't make votes, but if it's like, hey, go look at that, like, yeah, you can go do that. It's like, yeah, follow up on that. It sounds like we need more information. That's totally fine to do, but to divulge what's talked about within the closed session is not something that you should do. Okay, so you're not disclosing that beyond the body. We just talk here, and then go out. So, let me see really quick, Commissioner Fackrell, you were talking about, trying to give better notice. I think other than that, that's all I have, but there was a provision that says this is the bare minimum, but a public body may make greater efforts to be more transparent, or to, let more people know about what's going on.
Okay, question on that.
Yes.
May. Where we've got it on our agenda that somebody that wants to speak in a meeting has to let somebody know 48 hours in advance. 48 hours is Sunday afternoon. How's that going to occur?
I'm not sure. I think they'd have to.
We probably ought to change
Get in
that, just like
touch.
the rest of it would be a 24-hour notice somehow or another to be able to be available. Because in the code, it does not tell us we have to do it 48 hours in advance. It's 24 hours in advance for any public meeting. And I'm not even sure you have to do that.
It
says 48 here. If they want to virtually in any public comment listed on the agenda,
It says 24 above that, 48 below.
yeah.
So you
And
just
so
want me to update that
48,
to 24?
yeah, we need to put it as 24 because most of the public doesn't even see it. Depends on when the agenda comes out. Does not see it until Sunday afternoon or Monday morning. And so just as a clarification, I don't think in the code it says that they have to let us know 24 hours or even 48 hours in advance. I think there's something that they can just let you know in advance so that they can prepare or to have it there as a comment. And I think we need to make sure on that.
I think it's at least
Code.
24 hours. I can find that.
It was in the last legislation that I think we had on this. open
Yeah,
meetings.
I mean, I read it today as I was going through. I didn't highlight it specifically, but so here's the one I'm remembering is if, for example, one of you is unable to attend and you're attending, the public body has to provide the link at least 24 hours.
Correct.
Which I don't know if we have always done that, but
So
Well,
we've asked,
hopefully-
like, commission and planning commission, that if they need a virtual attendance link, that they let us know at least 24 hours in advance. Per our policies and procedures for the commission, we're supposed to notice that on the agenda if you're going to attend virtually. So that's the 24-hour requirement there. And then it's not public. We don't give that link to participate to the public. We give them the ability to watch it. So we have to create that link, and that's when we have to set up all the mics and the owl and stuff like that in the middle. Like, that's not a...
Okay, that's something we may want to be in discussion as a commission, that we need to be able to allow public to, 24 hours in advance or whatever, because there is a code that was written last year in that code that we have to allow the public to electronically be able to, and I'm not sure of the
it's
time
only
frame.
if we are holding an electronic meeting.
No, that is for every single meeting. And any meeting that we're holding, like this meeting here, and it's in the code, and we need to look it up.
Okay.
I'm not sure
Well,
exactly where
let's
it's
talk
at.
offline, because I just read it today, and I was
Yeah.
like, okay,
This
if we
is
do
for
this, then we
public.
have to do that
This was
as
for
well.
the public to be able to comment
Right.
under public comment time. And so we just need to verify that. That's all I'm asking.
Yeah, I understand. And so 6A, this is one that I didn't specifically go over, but it shall provide reasonable specificity to notify the public as to the topics to be considered. And so it's the topics to be considered, not necessarily all the details of those topics, but that doesn't restrict from being more detailed in an agenda as well. But the bare minimum is the topics so that they can choose to participate or not.
Okay, so maybe we can discuss this later, but in this in the discussion. Like if I wanted to speak in a committee meeting or something at the state legislature, I do not have to notice them in advance. There's an area that I can click on that I would like to talk with them in the committee meeting that we can do. So if that's something they're doing at the state level, we ought to find out from them how we can do it within our level, so that people, if they want to during a comment period of time, that they are allowed to speak. Just something we might
agree.
want to consider.
But that wasn't related to the last thing I read, right? Okay.
It wasn't.
All right.
That
Sounds
has to
good.
do with electronic public people in the public making comment without having to come here, that they can come and talk to us. That's all.
Okay.
Okay,
All right.
done?
Thank you. Yeah.
Okay. So we're going to hold a closed session for a few minutes. I'll need a motion on that, though.
I'll make that motion.
I'll
Okay.
second it.
Do we have to state the
We
reason?
have to state
Oh.
the reason why.
Oh.
What would you, I guess it
So
could be under
pending or
two-
reasonably imminent
litigation.
litigation.
Okay.
So I make a motion that we move into a closed session to discuss possible imminent litigation,
Reasonable
Pending
and
or
pending.
reasonably imminent.
pending or reasonable litigation.
I'll second that.
All in favor?
Aye.
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 Any opposed? Okay.